Today I am here to announce that Judge Charlene Olmedo held David Anthony Burke, who goes by the name David spelled D4VT, to answer for the horrific and barbaric killing of a 14-year-old at the time, Celeste Rivas Hernandez.
That's DA Nathan Hawkman out of LA talking after the conclusion of David's preliminary hearing. We are going to tell you what the court decided regarding whether or not this accused child killer is going to go to trial. And we just got a really big glimpse into what this defense may be. And I will tell you right now, it is shocking. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber.
Judge Charlene Olmedo's ruling took 11 words to read into the record. Sufficient cause exists to hold the defendant for trial. 11 words. That's all it took to move David Anthony Burke, known publicly by his stage name, from accused to arraigned, from innocent until proven guilty, to a man now facing a jury with special circumstances attached that make him eligible for California's death penalty. Picture this: a Tesla towed to an impound lot in Los Angeles, sitting untouched for months while its owner boarded flights, dropped songs, and lived in public view. Inside that car's front trunk, a discovery that would take investigators back through years of text messages, location data, and a timeline that started when a girl was 12 years old. That image, a luxury electric vehicle, silent in a tow yard, holding what it held, is the entire story in a single frame. Keep that image in your head. Everything else is just the paperwork catching up to it. Before we go deeper into what the records actually show, make sure you're subscribed to the Crime Infinity, because we don't just cover the story, we follow the evidence. Here's what the preliminary hearing actually established, stripped of theatrics. Over 5 separate court days, Deputy District Attorney Beth Silverman and her team, working alongside LAPD's Robbery Homicide Division, built a timeline running from 2022 through September of 2025. Celeste Rivas Hernandez was 12 when the interactions with Burke reportedly began. She was 13 when prosecutors allege a continuous pattern of sexual abuse took hold. She was 14. She never saw 15 when she went to a residence in the Hollywood Hills on April 23, 2025, and, according to the prosecution's account, never left alive. The paper trail. That's the phrase you'll hear again and again in this case, because it's the one thing neither side disputes. Cell phone records. Vehicle telemetry from the Tesla itself. Thousands of text messages spanning years. The evidence isn't hidden in shadows. It's sitting in server logs and infotainment systems, time-stamped and geotagged. The kind of digital exhaust that modern life leaves behind whether you want it to or not.
Allegedly killed. Now, first we heard from Beth Silverman, Deputy DA prosecuting this case. When she had this LAPD detective, Corey Farrell, on the stand, they presented select text messages from hundreds, thousands of messages between the two during these 2 or 3 nights. And they were meant to basically just establish time, location, the two of them arguing, the two of them coordinating when and where to meet up, the two of them deciding on a pickup location for the Uber, and then Celeste alerting David when she apparently got into his home just after 10 o'clock in the evening on April 23rd, 2025, and asking him to let her in. So very basic facts there, just establishing the two of them were communicating, they were planning on meeting up, and Celeste said in her text message to David that she had arrived. Now, then on cross-examination, Blair Burke was questioning LAPD Detective Corey Farrell, and she asked to show the court additional messages from that same conversation. That's where we started to get a little bit more color about the argument that has been referenced previously in the prosecution's charging documents. This is where we actually saw text messages from Celeste to David threatening him. Let me paraphrase for you some of this. In those messages that were shown to the court that Detective Farrell read to us, Celeste tells David that she's going to ruin his career. She tells him that she's going to tell her father lies about him. She tells him that she has contact information for his business associates, and for his mother, she tells him that she's going to call his mother, Colleen Burke, and tell her damaging information about David. Now, we previously have not seen these messages. We didn't really have a sense of exactly what was said in the argument between David and Celeste leading up to the night of April 23rd, when she allegedly died at his hands. So hearing this now and seeing all of this actually in print on the overhead monitor in the courtroom, it adds a little bit more color and life to this.
And to be clear, the reason this matters, it not only is potentially going to support the prosecution's narrative that he lured her there.
Now here's where the case stops being simple. The defense, led by attorney Marilyn Bidnarski, didn't dispute the timeline. They didn't dispute the location data. What they disputed was the meaning of it, arguing the prosecution has evidence of a body being concealed and transported, but not evidence of a killing.
Now in their closing statements that there did not need to be an ongoing or pending criminal investigation for that special circumstance to be applied. Here's where there might be an issue, though. Lying in wait. It seems to me, based on the text message conversations we were just parsing through in the courtroom, that Celeste was actually the one who demanded she and David have this meeting on the evening of April 23rd. She was the one who pushed him to have an in-person conversation. They were fighting about whether he was dating somebody else. She became very upset after seeing social media posts featuring the two of them. And it sounds like that was what triggered this argument. So she demands to see him. He tells her no. He's getting ready for a trip to Singapore. He says his parents are there visiting. He doesn't have time. She demands to see him. And finally, he gives in. So we previously did not know that about this argument. We thought that he arranged it.
Well, he did get her the Uber, right? So it's interesting. I was listening to what the prosecution was arguing. They said lying in wait doesn't mean a surprise attack, but they're saying he's the one who got her the Uber, got her to go to the house, right? And we still don't know what actually happened in that house, because I have to tell you, when we're talking about potential now holes in the prosecution's case, didn't we learn a thing or two about potential surveillance footage and the Uber driver that may not be so helpful to the prosecution's case?
That's the legal distinction the entire trial may hinge on, proving not just that a 14-year-old died and was dismembered, but proving intent, premeditation, and the specific special circumstances that elevate this from murder to a capital case. And this is where the ticking clock starts. Because if the defense can chip away at even one of those three special circumstances, lying in wait, murder for financial gain, or murder of a witness, does the death penalty stay on the table?
Absolutely. I was wondering last week, as the prosecution was calling their witnesses for this preliminary hearing, are we going to hear from that Uber driver at any point? You know, we've heard about that piece of the investigation for months now, that an Uber picked up Celeste in Lake Elsinore, where her family lives, and then dropped her off at David's home, just about 80 miles away in the Hollywood Hills. We haven't heard from this Uber driver yet. Well, that came up today in court. Apparently, LAPD did interview that Uber driver, and he denies having any recollection of that trip. He cannot definitively confirm that he dropped her off at that time, just after 10 p.m. that night, and he does not remember picking her up or driving her there. That is absolutely a hole in what the prosecution has been alleging for months now.
And no surveillance footage of her showing up or him being at the house, which, if I'm reading it correctly, again, seems to be problematic, which I know I'm jumping around a little bit because I do want to get a little bit back into what the prosecution was arguing with Detective Farrell. But something else that really stuck out to me, they are mounting, as far as I can see, and I think the court referenced it, a potential self-defense argument. I mean, when I'm reading these messages, there was an aspect to it, and correct me if I'm wrong, did Celeste physically, or are they trying to suggest Celeste physically threatened David, and that perhaps when she got to his house, he acted in self-defense? Am I looking at this completely wrong?
You're not. We've talked about a couple different defenses that attorneys have been, I think, either laying the foundation for or exploring as a potential option if or when this does go to trial. And I think this self-defense argument may be the one they have the strongest foundation for right now. As to the point you're making about physical assaults from Celeste, that was actually stricken from the court record this morning. The judge explained she is the victim here. She is not being charged with assaults. So until this goes to trial and the defense is presenting a self-defense argument, that's simply irrelevant. But that did come up, and it sounds like there may be evidence relating to that we could hear at a later date. But to your
Ask yourself that as we go through what each side actually presented, because the answer isn't obvious, and it's the single question this entire trial will be built around. The paper trail doesn't lie. That's turning point number one. The prosecution leaned on this idea hard, showing the court that David's phone and David's vehicle moved in tandem the night Celeste died, leaving the residence roughly 90 minutes after she was documented arriving, driving north toward a lake more than 60 miles away, stopping at a charging station along the way. Photographic evidence from the vehicle's own infotainment system was shown directly to the judge. This is the kind of evidence that doesn't require a witness to be believable. It just requires the machine to have been running. But the defense found the cracks. And they're real cracks. The rideshare driver who allegedly transported Celeste to the residence that night has no memory of the trip and cannot confirm the pickup or drop-off. There is no surveillance footage, not one frame, showing either of them entering or leaving the home. Investigators say the home security system had overwritten itself by the time they went looking, months after the fact. No footage of her arrival. No footage of her death. No footage of anyone leaving with anything. The paper trail doesn't lie, but the cameras were empty.
The point, Jesse, about that surveillance footage or lack thereof, absolutely. I mean, there is irrefutable hard evidence for so many other things, right? Phone records, Tesla records, text messages that spell out what people were saying and doing at specific times. There is no surveillance footage actually showing David or Celeste going into or coming out of the Doheny Place home where he was staying at the time. The LAPD detective, Corey Farrell, the final witness for the prosecution during this preliminary hearing, he spoke to that today. And he laid out what I thought was a very reasonable explanation. He says by the time they tried to access that security system to search for that video, it had been so long, it had been months, and the system simply overwrote itself. It wasn't stored there anymore. Now, we don't know if somebody may have gone back and deleted that. We don't know if the cameras may have been turned off during that time. All we know is there is no video. So what the prosecution has been alleging this whole time, that David stood by and watched the victim bleed out, well, there's no video documenting that. So we have to wonder, Jesse, if they're going to call another witness to the stand during the trial who can say that they saw that happen.
Well, I think what I was hearing today from the prosecution is they're assuming that happened because the argument would be there was no outgoing calls to emergency services. Although it seems to be complicated a little bit because the defense was saying your medical examiner, right? The medical examiner said that we don't know how long it took for Celeste to succumb to her injuries, right? So this idea that you claim our client was watching her bleed out, it seems that it's complicated by the ME's testimony, right?
That's right. I mean, he testified the other day, either one of those two penetrating wounds that they attributed her death to, either one could kill somebody in, quote, minutes to an hour. That is a pretty wide window of time. And he simply can't say, and that's because of the advanced state of decomposition. She may have been dead for weeks to months before her body was found. We saw in very graphic imagery exactly what her body looked like when the pieces were found in body bags inside that vehicle. So he can't say which penetrating wound happened first. It took them about 3 months just to finalize their autopsy findings and confirm her cause of death. So he doesn't know what kind of instrument or weapon caused those injuries. The body goes through a lot of change post-mortem.
Sure.
So
That's turning point number 2, and it's the seam the defense is going to keep pulling on all the way to trial. Then there's the medical examiner's testimony, which complicates the narrative further. Celeste's remains were in an advanced state of decomposition by the time they were found in September, months after prosecutors allege she died in April. The medical examiner could not determine which of 2 fatal wounds occurred first, and testified that either injury could have caused death anywhere from several minutes to an hour later. That window matters, because the prosecution's theory involves the defendant allegedly remaining in the home while she died. A range of minutes to an hour is not the kind of certainty that closes a case. It's the kind of ambiguity a defense team builds a reasonable doubt argument around. And then came the text messages, the ones that hadn't been public before this hearing. Messages the defense introduced showing Celeste, in the hours before her death, telling Burke she planned to expose him. To his mother, to people connected to his career, to anyone who would listen. She referenced material she had. She referenced people she intended to contact. The prosecution says this is exactly what establishes the special circumstance of murdering a witness and killing for financial motive, silencing someone who threatened to end a career and expose a crime. The defense is walking a different path with the same messages, laying groundwork for what may become a self-defense argument at trial. Though the judge struck related claims of physical confrontation from this hearing's record, ruling them irrelevant at this stage since Celeste is the victim, not a defendant. The paper trail doesn't lie, but paper alone cannot prove what happened behind a closed door.
I thought another interesting point was about Celeste's family. There seemed to be a big conversation today about what did they allegedly know or seemingly know about David's purported alleged illegal sexual relationship with Celeste, which, by the way, and we'll talk about this in a minute, the prosecution said even if there's this idea that David was mistaken about how old Celeste was, that's not a legal defense to the charge that he's facing. And we talked last week about all the alleged imagery and photos and text messages potentially proving their sexual relationship, which is, pretty disgusting to say the least, that whole conversation. But the point is, I have to bring it up. There was testimony today regarding what Celeste's family knew. And if I'm reading your notes correctly, did her parents walk in right as this was happening?
So to be clear, Jesse, as you stated, and the prosecution made this very clear in court today, several different ways, it does not matter how old Celeste told David she was. That does not absolve him of these child sexual abuse charges. It does not matter if she lied to him about her age and said she was 18 when she was 13. That does not change the factual substance surrounding that particular charge, sexual abuse of a minor under 14. It also does not matter that her parents consented to letting her travel with him. It also does not matter that her parents, her aunts, her cousins, and apparently her older sister were aware that she spent time with him, went to the mall with him, went to the movies with him. That does not make it okay for him to have sexual relations with this child. So that did come up. And I think that's part of this bigger story, right? We're getting a more colorful picture of what was happening around not only David, but Celeste. Yes, it does seem like, based on the evidence shown to the court today, people around her, including her family, they were aware the two of them spent time together. But beyond that, we don't know if her parents were aware of this purported abortion that happened in January 2024. And let me just remind you, in January 2024, Celeste was still 13 years old. We don't know if her parents were aware that he was instructing her to take Plan B. We don't know if they were aware of who she was with, and what they were doing when she ran away from her home in Lake Elsinore at David's prompting. He called that OA. He had a name for those runaway operations. He called them Operation Awesome. He was talking to her over text in records that we've seen. He was talking to her about getting married, starting a family. He told her over text, you know, if you have twins, great, because we wanted 2 kids anyway. She was 13 years old when they were having those conversations.
That's the third and final turning point, and it's the one this entire trial will be decided on. Outside the courthouse, District Attorney Nathan Hawkman was direct about what comes next. An arraignment is scheduled for August 31st. Bail has been denied. A trial could be set as early as 60 days out, and Hawkman made a point of noting that what the court saw during this preliminary hearing was, in his words, only a small fraction of the total evidence the prosecution intends to present, additional material that couldn't be introduced under preliminary hearing rules but will be admissible at trial under a higher evidentiary standard. He also confirmed that a decision on whether prosecutors will formally seek the death penalty has not yet been made, and that the defense will have an opportunity to make submissions on that question before any final determination.
Good afternoon. My name is Nathan Hawkman. I'm the Los Angeles County District Attorney. Today I am here to announce that Judge Charlene Olmedo held David Anthony Burke, who goes by the name of a singer David spelled D4VT, to answer for the horrific and barbaric killing of a 14-year-old at the time, Celeste Rivas Hernandez. She has held him to answer for first-degree murder with the special circumstances of lying in wait, doing this crime for financial gain, and murdering a witness to an investigation. David Anthony Burke has also been held to answer for the mutilation of the remains of Celeste Rivas Hernandez on September 8th, 2025, and he has also been held to answer for engaging in continuous lewd and lascivious acts with a 13-year-old. What we have seen in this preliminary hearing, and the preliminary hearing was conducted by one of our most experienced deputy district attorneys, who is right here, Beth Silverman, and her team, working with the Los Angeles Police Department's Robbery Homicide Division. They methodically presented over 5 different days before Judge Olmedo the evidence that showed, and at this point we had to show it by probable cause, but by probable cause, and I would argue by an overwhelming amount of probable cause, and we will eventually prove this beyond a reasonable doubt. It followed the timeline of the interactions between Celeste Rivas Hernandez when she started as a 12-year-old, then a 13-year-old, then a 14-year-old who never got to see her 15th birthday. Because in the intervening time where she had these interactions with Mr. Burke, he engaged in this sexual conduct with a 13-year-old repeatedly, over and over again. This came out in text messages that were presented, in videos and photographs that were presented to the judge that showed this sexual activity. Ms. Silverman methodically tracked the timeline of their interactions during 2022, 23, 24, 25, that eventually led to the time where Celeste Rivas Hernandez went over to Mr. Burke's house in the Hollywood Hills on April 23rd, 2025, and has never been heard of again. But what Ms. Silverman and her team were able to show to Judge Olmedo is that on April 23rd, 2025, what actually happened was the brutal and horrific murder of Ms. Hernandez, and thereafter, over the ensuing 5 months, how her body was chopped up, left in the front trunk of a Tesla, only to be discovered on September 8th, 2025, after the car, and this is Mr. Burke's car, had been towed to a tow yard. What now happens is that there will be an information that will be filed within the next week or so. That information will track these 3 felony counts that have already appeared in the complaint. August 31st will be the arraignment on that information. Thereafter, there will be a trial that will be set. That trial can be set as early as 60 days. And as we saw with the preliminary hearing, where the defense demanded that they have that preliminary hearing done within the time that the law allows, whatever time they want a preliminary hearing, we were ready. Often preliminary hearings in a case of this complexity take many, many more months than you have seen in this case. But when the defense demanded a quick preliminary hearing, we said, bring it on. And that's exactly what we did. If the defense wants a trial 60 days out or whenever they want this trial, we will be ready for that trial. So at this point, again, we don't have the one additional consideration is that Mr. Burke now is eligible for death penalty. The death penalty considerations are now being weighed. Part of that consideration will be any submission that the defense wants to submit to the district attorney's office. It is something that we will consider on whether or not we will seek the death penalty. At this point, the death penalty determination has not been made. I will now open it up for questions.
It's worth sitting with what the DA said about the burden ahead. Probable cause is, by design, one of the lowest legal thresholds in the American justice system. Enough to move a case forward, not enough to convict. What happens between now and trial is prosecutors converting a mountain of digital records into something 12 jurors can unanimously agree meets proof beyond a reasonable doubt on 3 separate felony counts, each with their own elements that must be independently established. And it's worth sitting with what the family in that courtroom sat through. A mother and father who lost their daughter and are now required to relive, in granular legal detail, the exact mechanics of how they lost her, timeline slide by timeline slide, message by message, in a public courtroom, because that is what accountability under law demands of the people left behind.
So again, we have said this before, the unspeakable tragedy that the Rivas Hernandez family has had to go through to first lose their daughter, but to then find out how they lost their daughter is something that there are no words to do. All we can do at the district attorney's office is bring justice in this case by bringing that killer to justice. That killer is David Anthony Burke, and we intend to bring him to justice before a jury at a trial in the upcoming future.
One more question.
Right here. Again, at trial, we will bring in all relevant evidence that will establish all the elements of the crimes that have been charged. You heard a preview of that evidence in the preliminary hearing, whether it was, again, certain witness testimony, certain text messages, videos, photographs. There will be business records, and there will also be witnesses that are precipient witnesses. They have information that is relevant to establish the mental state of David Anthony Burke and the acts he committed. That evidence will be presented at trial, at the end of which we will be seeking a verdict of guilt on the 3 counts of which he will be charged: first-degree murder with the special circumstances of lying in wait, doing it for financial gain, and eliminating a witness in connection with that case, mutilation of human remains, and engaging in a continuous series of sexual acts with a minor that are lewd and lascivious.
If you want to follow this case with the same rigor we do, the underlying charging documents and the DA's public statement are filed with the Los Angeles Superior Court and available through the county's public case index under Burke's legal name. Not the source material for opinion pieces, the actual filings. Pull them. Read the special circumstance allegations yourself in the exact legal language prosecutors used. Here's the question we want in the comments. Given what the medical examiner couldn't determine, the exact cause and timing of death, and given the total absence of surveillance footage, do you think the special circumstance of lying in wait survives to trial? Or does the defense have enough to get it dismissed before a jury ever hears it? If this breakdown helped you understand what actually happened inside that courtroom, hit like, share it with someone following this case, subscribe to the Crime Infinity, and turn on notifications, because we'll be back the moment the arraignment happens on August 31st, following the evidence, not the noise.